Chief Justice Gilday, and may it please the Court. My name is Jordan Lawrence, representing the petitioners. We argue that the way to resolve this case is to give effect to both Minnesota Statute 204D-15 as well as the two validly enacted ballot titles by the legislature. All of these are legislative enactments that the legislature has done, and to look at the plain meaning of all of them gives the right answer, and to give full effect to each one of these things. Now, the statute was passed under the Minnesota legislature's authority to pass ordinary legislation, but the ballot titles were passed under a different and distinct authority to amend and to propose constitutional amendments. And so that even though these, at times there have been statutory matters that have been put in these constitutional amendments, the voter ID amendment and the marriage amendment did not contain any of those at all. They were 100%, both of them passed under the legislature's authority to propose constitutional amendments. This Court has understood that authority to be quite broad, that it is said that it oversees the form and manner of submitting the question of a constitutional amendment to the people. And even in the earliest days of the state, you would see the state legislature dictating the exact language that would appear on the ballot, and that, or the positioning of where, when there were multiple amendments, where they would appear on the ballot.
Counsel, let me just ask you a question about your argument. Is it your argument that the statute 204D.15 is unconstitutional because the legislature in that statute unconstitutionally delegated authority that the Constitution vests exclusively in the legislature?
Only that is a secondary argument that I don't think you need to find that to reach that. Only if you agree with the Attorney General that the only way that the legislature can get back its authority to propose constitutional amendments and everything around it is by amending that statute. The way that I would urge this Court to interpret is this, is the statute says that the Secretary of State is to provide an appropriate title and then submit it to the Attorney General for the Attorney General's approval. What the legislature did first with the Legacy Amendment in 2008 by a DFL legislature and then by Republican legislatures with the Voter ID and the Marriage Amendment is to basically state an appropriate title under this statute is the following language.
Well, except that they didn't say that.
What? I'm sorry.
I mean, they didn't say that.
Well, I think,
they didn't
that that's what they did say.
That. And in the statute itself, the legislature didn't say in 204D.15, if we pick a title, that's the only title that the Secretary of State can use.
Well, I think that it's not quite as rigid as that. The way that I would say it, Your Honor, that the statute says the Secretary of State shall provide the appropriate title. And then the way that the legislature with the Legacy Amendment and then with the Marriage and the Voter ID Amendment basically stated that the title required under the statute 204D.15 for the question submitted to the people shall be. So they're saying we're stepping in with our greater authority to propose constitutional amendments and saying this fulfills your duty. Now, this very same Secretary of State and Attorney General with the Legacy Amendment understood the way by their actions what happened, because they did not send letters back and forth as the statute requires. So when the Legacy Amendment came forth in 2008, they viewed this as fulfilling the statutory duty. They said something to the effect like the specific outweighs the general, takes precedent over the general. The more recent in time takes precedent over this general residual statute here, and they basically acquiesced to the point where the Secretary of State didn't even send a letter to the Attorney General, and the Attorney General didn't say, hey, I'm waiting for that letter under Statute 204D.15. So we think that their behavior with the Legacy Amendment is consistent with this understanding of this.
Counsel, can I stop you for a second? I know that you are arguing the statute, and maybe my question is misdirected, but doesn't the manner in which we construe the statute depend on what we do with the language in Article 9, Section 1, And by that I mean the statute or the constitutional provision says that the legislature has the power to propose constitutional amendments. And it seems to me that how we determine that word propose broadly or narrowly determines whether or not it is the legislature's conclusive or exclusive constitutional power to amend the Constitution. And then, depending on how we determine that, we get to the statute. It seems to me going to the statute first is putting the cart before the horse. Well, I hope that's an appropriate use of the word horse.
Yes.
I think it's the plain meaning of the word there. Justice Deason, I think that this court has answered the question in the first case that I can find is the 1898 case of the Mars v. Stern, where it said that they construed Article 9, Section 1, that to apply to not just the four corners of the text of the amendment, but to the form and manner of submitting the question of the constitutional amendment to the people.
Well, I understand that, but what I'm getting at is I'm looking at the Constitution. We've interpreted the Constitution in terms of what propose means, and we're still left with how broadly we interpret propose, and I think it's a close question, and I guess my question to you is why would we not interpret propose to be limited to those ballot format issues in which voters will actually vote? And this title is not something upon which voters will actually vote.
Well, the state constitution and the way this court has interpreted it, as well as the way the state legislature has acted since the Minnesota entered the Union, was to view this as a pretty broad grant of power to dictate this. And I would also point out, if this is helpful, is that the drafters of the Minnesota legislature seem to understand that there's various types of power that they were distributing to the three branches of government. And they clearly know how to say, with passing ordinary legislation, the executive branch and the legislative branch have to work together. But then there's other things, like, for example, appointing vacant judgeships. That is it's the executive branch, it's the governor and the voters. Constitutional amendments, it's the legislature and the voters. So they seem to be able to know when to make things a combined effort and when to separate that and just have one branch and the voters. And so it seems to me that if that's the construct that they have, to have the legislature puts together.
It seems to me, I guess what I'm getting at is you, therefore, it seems to me, argue that propose is interpreted very broadly, as we did in Stearns. And if that's the case, it seems to me that when we get to the separation of powers issue and the statute here, that you logically would have to argue that since the legislature, interpreting the Constitution broadly, has the exclusive constitutional power to determine constitutional, to how the form and manner in which they're put on the ballot, that therefore that is a non-delegable duty and the statute is therefore unconstitutional. And well, I don't hear you making that argument, and I guess why would that not logically follow from your argument?
Because I don't think that this is a delegation of authority under the statute that is unconstitutional. I think and I make this as a contingent argument, if this court agrees with the Attorney General that the only way the legislature can change the ballot title is by passing a bill amending 204D.15 that's subject to the governor's veto, and if the governor vetoes it, then they just can't exercise their constitutional authority. I think then, in that instance, the statute would be unconstitutional. But I think there's a way to read all of these enactments together, the ballot titles and 204D 15, that the statute is the general default drive, and that when the legislature steps in and says anything different, here's the ballot title, this fulfills the duty, the statutory duty under 204D.15, then I think you get all of this working together. I think then it all operates and it's all valid and nothing has to be struck down as unconstitutional.
Counsel, let me follow up on that question, which is, it seems to me, and maybe you make this argument, I didn't see it in the briefs, but the argument you're trying to make, I think, is the first sentence of Section 204D.15, Subdivision 1 says, the Secretary of State shall provide an appropriate title for each question printed on the pink ballot. I think you mentioned that in response to the Chief Justice.
Yes.
It seems to me that the argument you should be making, and maybe you did make it, I didn't see it, is that when the legislature provides its own title, that the only appropriate title that the Secretary of State can put on the pink ballot is the title that was passed by the legislature. Maybe you're making that argument, maybe you're not. It's not clear to me what argument you're making. Is that an argument you are making?
Yes, we are making that argument, and I appreciate you stating it more clearly than I'm trying to state it. Is that
where is that stated?
On what page of our briefs?
No, not. Oh. Where in the legislation or in the Constitution is that stated?
Well, it's not in the legislation, but the legislation doesn't say the legislature is the Secretary of State is the only one to do a ballot title, and the legislature can never take it back. I don't think that it's not an exclusive grant of authority. It's a delegation of authority in the statute.
It strikes me that the legislature can clearly take it back by changing the statute.
But I think they don't have to because they're acting under their separate, distinct grant of authority to propose amendments, that they're not just bound into kind of a narrow universe of just passing legislation, because that means that the governor...
Well, assuming for the moment that they are acting within their own authority,
yes,
their exclusive authority, they've still enacted this legislation, which, I mean, it seems to me you can't change it on the fly.
Well, I think that
or can you?
Well,
I guess that's the question.
I think that you can because you have the intersection of two different deposits of constitutional authority in the legislature, one to pass ordinary legislation and one to propose amendments. And how do they interact? And I think what the government's position is that the Attorney General's position is that the legislature has given away that authority and they can't take it back unless they amend the statute. But then what they say is then we give no effect to these ballot titles that were passed with the Legacy Amendment, marriage, and voter ID. And I think that the way that gets... Well,
did anybody challenge the Legacy Amendment title?
They did not. And
so that doesn't help us very much, does it?
Well, I think only to the extent that the Secretary of State acquiesced to the directive of the legislature in 2008, this very same Secretary of State and Attorney General, when they had basically the same wording. That was basically, I think, the text of that is saying, the legislature is saying, we're aware, this is my amplified version.
It's not necessarily inconsistent for presumably the Secretary of State to agree with the title that the legislature comes up with.
But they're still under a statutory duty to write the letter. Now, if there was a letter that I would agree with you if this had happened, the Secretary of State said, look, I have this independent duty under statute 204D.15. I'm writing this letter. I kind of like what, I like the legislature's title. What do you think about it, Attorney General? Yeah, let's put that in. They didn't do any of that. They viewed the legislature's act by saying this is the title that is the appropriate title, as Justice Strauss said. This is the appropriate title. We're bringing that. This totally fulfills all duties under 204D.15. And that's what the current legislature did with passing these two amendments. And I think that it gives effect to all these valid legal enactments rather than saying the universe is limited to statutes. And when it comes to proposing amendments, if the legislature isn't talking or speaking through statutory enactments, it's not speaking at all. And I think that is just constitutionally too limited and incorrect.
Well, counsel, let me follow up on that constitutional argument, which is, and this is a problem I'm having with your argument, is you argue that this is not ordinary legislation because of the exclusive grant of authority on constitutional amendments to the legislature.
Right.
The problem I have is there's another exclusive grant of authority to the legislature. And Article 13, Section 1 talks about the uniform system of public schools. And the only branch of government that's mentioned in that provision is the legislature. And it talks about the legislature's authority in that area. If we were to accept your argument, one of the things we would essentially be saying, I think, is that if the legislature passes laws in the area of education, that the governor's veto would not be effective, because after all, the legislature has exclusive authority in the area of public schools. Am I correct about that?
I am not as familiar as you are, Your Honor, with that provision, but I think that you have an interaction of appropriations when you're coming to public school bills, as well as substantive policy statutes that are passed, and I think there will be more complexity to it that I frankly have not thought out in my own mind. But I think it's different when you're talking about something like a constitutional, proposing a constitutional amendment. And I think that there is the parallel to appointing judges, that it's given exclusively to one branch and then goes to the voters. It seems like there's this model that the framers had in mind when they did this. And I don't know exactly how to answer your public school.
Well, let me ask this then. We have cases where ordinary legislation has been passed in the context of a constitutional amendment, and we've said in our cases that ordinary legislation is treated differently. We don't, you know, obviously we're going to separate that, and the governor can have the ability to veto that.
Yes.
What makes this different from ordinary legislation? What makes this sort of, because it seems to me that you've got the constitutional amendment and then you've got the ordinary legislation that goes along with it. And the legislature has passed a statute giving the Secretary of State authority to create these titles. Obviously, that was ordinary legislation. Why isn't this ordinary legislation?
Well, and you're correct. And from time to time, with some frequency, when the legislature passes a constitutional amendment, they sometimes have enabling legislation connected to it. Sometimes they do and sometimes they don't. And I think, and I have no argument, and I agree with this, that the governor has full veto authority over the ordinary legislation, and that there's not somehow a zone of immunity extended to that legislation simply because it's attached with a constitutional amendment. But I would say this, it's really clear in the way that the legislature designates changes to legislation and constitutional amendments, which part that they're talking about. And there's plenty of constitutional amendments that have no legislation attached to this. And I think that it's clear from the way they draft bills across the street here that they were not viewing the title as an amendment to the statute. Even though they mentioned the statute, they weren't viewing it that way. They were viewing it as something like, we're fulfilling, like you said, you need to find an appropriate, provide appropriate title. Here it is. You don't have to deliberate about this. You don't have to think about it. We're just giving it to you. That I think that that's what they were doing. And they weren't, because then we would see that in 2008, there'd be this amendment, you know, under 204D.15, oh, by the way, for the legacy amendment, this is what you do different. You know, this is an amendment. And so no one understood that to be an amendment. No one understood these to be amendments to statutes. These were simply fulfilling that statutory duty by the separate and distinct power of proposing amendments.
Counsel,
no, I'd like to ask a question. I've been rather silent this morning, and I want to get to something rather basic that's on my mind. And it's a follow-up to Justice Pietz's question. Basically, Counsel, where do you find the authority of the legislature to submit a question to the people on the ballot rather than the text of the amendment? Is it in Article 9? Is it in the statute? See, what really, I mean, I wish I'd paid more attention in 6th grade on diagramming sentences, but I look at the second sentence of Article 9, and it says, proposed amendment shall be submitted to the people. I mean, that seems to be clear, and it's odd to me that we can submit a question that kind of disappears into hyperspace after the vote, and there's an amendment that becomes part of the Constitution that is never directly before the people. So where does this authority to submit something other than the text come?
Well, that I'm relying on this court's interpretation since 1898.
So your reliance is not on the language of the statute.
Well,
I mean, of the Constitution.
I would say
It's on Stearns, it's on Duluth, and it's on Breeza, right?
Right.
And maybe Wingert and some others.
But I also think proposing an amendment is that there's a two-step process. It goes, the legislature proposes the amendment, then it goes to the people. And it seems that the only governmental entities that has plenary oversight is the legislature. So
okay, let me follow up on that, because I have a real hard time thinking that the sovereign people set up this structure, and maybe we as a court have to revisit whether it's dicta or holding. But if you say that the legislature has the sole power, does the legislature have the power then to submit a misleading or deceptive question to the people?
This court has said no.
I'm not asking. I mean, it appears to be the argument that the legislature can submit whatever it wants, and is that we have to be highly deferential. I mean, I want to know, because it seems odd to me as a court that the people would have confidence enough if we say, well, you know, the legislature can submit a question, whatever it wants, even misleading or deceptive. And I didn't get an answer last time to that question. I'd like to have it now.
Could you do that? My understanding of this is that
what's the antecedent for this? I just need to know, but I want to be clear what you're answering.
Can the legislature propose anything without any judicial oversight whatsoever? I would say no. This has not been the practice of this court. There might be some political question doctrine that would lead to that, but that would be a shift in jurisprudence that this court has never seen. And I don't think we have anything like that here, that this is just basically interpreting text the way that I see it.
So now that you've agreed that we have the power of oversight, what is the standard that we would apply?
What I would suggest is has the legislature acted in its authority to propose amendments to say what the title is? And I think that they have.
Oh, wait. You said that if it's deceptive or misleading, we have a right to do it. You just answer that question, say if they've acted and given a title, it doesn't matter.
I think that I don't think that that's the question that you have to answer here. I think that the question that you have to answer is who has the final authority to define what the title is? And I don't think anybody's been saying that this is so deceptive that people are going to think that they're, raising their taxes when they vote for the voter ID amendment or the marriage amendment or something.
I read Mr. Carl's brief. He says it's deceptive.
Well,
misleading.
That I think is who is the final authority on this. The Secretary of State says, I do because of the statute. We're saying the legislature does because of their inherent authority to propose constitutional amendments.
Counsel, let me ask you about your judicial analogy, and I hadn't quite thought of it in that context before, but at least as I understand your argument is that this is like the governor having the absolute or final authority when it comes to judicial appointments. But it seems to me that at least, and didn't go back, and I haven't had the opportunity to go back and look at the statute, but there's a statute in place that sort of defines the process for appointing district court judges and Court of Appeals judges, I believe. I could be incorrect. But it seems to me that your analogy falls apart in that the legislature has put some boundaries on the appointment process.
Well, I think that there's delegation because the executive could have vetoed that, and if the governor did not view that as or viewed it as an appropriate delegation, I think that would be appropriate. Now, if we had a situation where the governor appointed somebody who was learned in the law to a judicial vacancy that didn't follow some procedure, we might have the same situation here. Whether an independent grant of authority to fill judicial vacancies can be thwarted by the legislature because of some, and I just don't think
Which runs us into the constitutionality of the particular legislation.
Well, I think it would, if the narrow universe is only statutes and any other exercise outside of a statute has no effect, I don't think the Minnesota Constitution sets up these lobster traps for the power exercised exclusively by either the legislative or the
Let me follow up on that point directly, which is I actually think that the judge's example might be useful for showing why this is different, actually. So the judge's example, we have no judicial review over who the governor selects. I mean, the legislature doesn't have review over who the governor selects for any judicial position. But I actually think, and maybe you can address this, I actually think Breza itself and the Stearns case harms your argument. Because essentially what we've held in those cases is that we, as judges, we can debate whether those cases were wrongly or rightly decided, but those cases say that we as judges have the right to review the legislature's work product. And if it's so misleading that it constitutes a palpable evasion of putting this amendment before the voters, then, then we can strike it down. It seems to me it's very hard to make an argument that the legislature has exclusive authority over constitutional amendments when we, in fact, have held that we, as another branch of government, have authority to review those amendments. Could you address that?
Well, I think to be, I want to make 2 points to this, and I know my time is right now, so, Your Honor, may I just finish?
Yes, please. Go ahead.
The court can examine text in the Constitution and say, is this actually proposing an amendment? That would be something that I think would be justiciable for a court to examine, that it wouldn't be out in some sort of political question, no man's land, or something like that. And I also think the question before this court now, when I was addressing Justice Anderson, is not whether this is deceptive, it's who has the final say, because we have two governmental entities saying this is the title, and they're looking for, well, who's got the primary?
Well, that's true, but we've said we have the final say. That in fact we have the ability to go in and strike, potentially, at least under the language. We've never done it, but under the language of Stearns and Breza, we've said we have the right as the judiciary to go in and strike what the legislature's done.
Well, I think that there's something much more modest being asked here, is to say who's not to rewrite the title or to say which one's better, but to say who has the final say on this. Is it the exercise of the statutory authority or the exercise of the constitutional authority? That seems to be a much more limited text-based question in both the Constitution, the statutes, and these ballot titles that isn't getting into the kinds of problems that you're talking about. I understand what you're saying, but I just think that this isn't there. This is like, who has final authority here? And that seems to be like a question this court can resolve. Thank you.
Well, wait, I have one question.
Yes, question.
The legislature acted here. They came up with proposed constitutional amendment language. But it also proposed a question, proposed a title, and also in the past gave authority to the Secretary of State and the Attorney General. Yes. Is the legislature acting under Article 4 or Article 9?
When it proposed these amendment titles?
Yes.
I say they're acting under Article 9.
So that we would have to find the authority in Article 9 for what they did.
Yes, and I have to admit, I'm not familiar with Article 4, that's the...
Well, that's the one where it says that it goes to the governor reviews and vetoes, and you can...
Yeah, I think that this is in Article 9. That Article 4 is dealing with ordinary legislation. I think it can be delegated through that, but I don't think it can be given away in a kind of a permanent fashion.
Before you leave, let me just make sure. All right, I have Justice Page, I just have a question that I'd like you to address when you come up on rebuttal.
Yes.
And that is where in your petition you allege that the title written by the Secretary of State violates 204D.15. I know you make that argument in your brief, but I'm wondering where actually in the petition you make that assertion. If you could address that in
Yes,
rebuttal, I'd appreciate it. Justice Page.
And to the extent that the argument is that, you've delegated the authority under the ordinary legislation provision, why can't you delegate your authority under Article 9?
Well, I think that I think that they could. I think that they've delegated Article 9 authority through a statute. Now, I guess they could pass a joint resolution if this is, if I'm responsive to your question. They could pass a joint resolution that says the Secretary of State shall confer with the Attorney General for the ballot titles. I think that that would be valid. They don't have to do it through ordinary legislation when they're proposing amendments.
Thank you, Counsel. You have 5 minutes for rebuttal. Mr. Cardall, you have 5 minutes.
May it please the Court, I only have 5 minutes, and so I'm trying to be specific and advance the case a little bit. And so I would only be speaking with respect to the appropriateness of the title under 204D.15, which is the Chief Justice question. I haven't had a chance to review the petition while you asked that, but I'll continue on regardless. The standard review, I believe, of the title that the Secretary of State has proposed is de novo. The question is the title appropriate? The level of deference one might give the administrative decision here of the Secretary of State wouldn't be interpretation of a statute, Chevron deference, that'd be too high. It wouldn't be the deference according to administrative rule, Skidmore deference, that would also probably be too high. It's not an Attorney General formal opinion, so it wouldn't require that kind of deference. But we do need to give some deference, and so I propose using the Skidmore test, which I think would be appropriate. Skidmore has 4 factors. I'll go through them quickly. 1 is the thoroughness of the Secretary of State's investigation. It doesn't appear, based on the record documents, that the Secretary of State collected the proposed amendment, that is the title the legislature proposed. There's no evidence in the record that it was gathered and considered. I think this is pretty important because the legislative title is obviously appropriate with respect to photo ID.
Counsel, are there parts of the proposed amendment that are self-executing? By self-executing, I mean they will take effect without enabling legislation.
I believe that the photo ID amendment, which I'm trying to limit my remarks to, would require,
let's focus on that. Yes.
Would require additional legislation.
Well, but wait. As I look at the first line, photo ID will be required. Government issued photo ID will be required. See, I see that as self-executing. I mean, if it come back to me after this amendment is passed, and they say, well, no, somebody can go to the voting place and vote without government-issued photo ID, I'll tell you quite frankly, I said, well, no, we got a constitutional amendment that says you have to have it. And see, you're attacking what the Secretary of State says, and he says it'll change the form of registration. He said, no, nothing's happening here because we need enabling. I mean, that will change how people get to register on Election Day. And see, so what is wrong with the Secretary of State saying it will change voter registration?
The problem, Your Honor, in the first instance, the court looks at the record to see if the decision-making analysis by the Secretary of State is persuasive. And so here you had a reasonable alternative, that is the legislature's proposed ballot title, not even being
Well, let me get to that, because I've looked at the debates on the floor. I've read the briefs. Is that in the supporter, former Secretary of State Kiffmeyer, Representative Kiffmeyer, says that this amendment will not change absentee balloting, mail-in voting. But I've looked at the regulations, I looked at the requirement. Absentee balloting does not require photo ID. And so now I would say that the legislature's proposed question is maybe as deceptive or more than what the Secretary of State, because it says photo ID required for voting, but we have the sponsor of the bill saying, no, it doesn't change it for absentee voting, it doesn't change it for mail-in. I'm confused as to what it does or doesn't do.
Your Honor, I empathize with the court this confusion. But the point is that the court should have an administrative record before it, where the Secretary of State has weighed those very things that you're describing. And the absence of such a record under Skidmore deference, it means that this court should not give any deference at all to the Secretary of State's actions. And yes,
What deference should we give to the testimony of the bill's sponsor?
That, Your Honor, would not be administrative history, which would fall under Skidmore deference. And so that would be off the point. What we're reviewing here is the Secretary of State's titling decision, and we're trying to determine if the Secretary of State used a process which you should defer to. And based on the record, the Secretary of State failed to consider the legislative language. And this is a concern. The concern is, why didn't the Secretary of State and the Attorney General, as part of their duty, provide a written analysis why the legislature's title was inappropriate and the Secretary of State's title is appropriate?
Well, didn't the governor veto that language?
Yes, interestingly, on the photo ID question, the governor referred in his text, he referred to the photo ID amendment. The Attorney General's letter 3 times refers to the photo ID, in the purpose letter, refers this as a photographic identification amendment. And so our concern is, why isn't the photographic identification referenced in the Secretary of State's title, and we don't have any analysis to look at? Why didn't the Secretary of State consider using the phrase photographic identification in the title? And there are a couple things that we should consider when looking at that. One is, of the 5 sentences of the proposed amendment, 3 of them contain the phrase photographic identification. The 4th sentence includes a reference, substantial equivalent. So it is about photographic identification. The state legislature proposed a title that included the phrase photographic identification. Here the Secretary of State has failed in the analysis to even consider using the phrase photographic identification. And that, I believe, is inappropriate, because when there's a proposed amendment that is so heavily focused on this idea of photographic identification, it's hard to fathom how a proposed title cannot include that phrase. And the only possible conclusion this court could come to is the Secretary of State and the Attorney General didn't do any legal analysis. They didn't analyze the question, should photographic identification be included?
Hang on, Mr. Cardall. Justice Anderson has a question.
I gather you would agree that if, well, I shouldn't say I gather you agree. I'll just ask you if you agree. If the Secretary of State had kept the language that he had proposed, but had included the photo identification reference, at a minimum, your argument here today that the Secretary of State's language was misleading would have become much more difficult. Am I right about that argument?
Yes, my argument would be much more difficult if the phrase photographic identification had been included. However, I am arguing for a lower standard of review because of the statute. But thankfully, violating statutes is under de novo review, not this more deferential standard given the ballot question, the first photo ID case. And so our position is that, yes, of course, the court has an opportunity here to review whether this was an error not to include the phrase photographic identification in the Secretary of State's title. And even though I admit it's a small record, it's an important decision regarding the proposed amendment. And so we must search the record for any thoughtful analysis the Secretary of State has provided or the Attorney General in the approval letter, and there is none. In fact, the last test I'll mention under Skidmore analysis is there inconsistency. And Justice Anderson referred to the governor's veto letter. There's the Attorney General's purpose letter. These two refer to the proposed amendment as photo identification. And then you look at the Secretary of State's titling letter and the Attorney General's approval letter, and they don't mention it. So that's an inherent contradiction in a short period of time. And this I believe is the reason why it's inappropriate, is there's nothing for the court to defer to, and the court then, as far as the administrative decision, so the court needs to reason through it what would be appropriate.
Hang on, Justice Strauss has a question.
I just have a quick question that will require a very quick answer, which is Skidmore was only recently revived by the U.S. Supreme Court in Christensen and some of those cases. I'm unaware that we may have a case that deals with Skidmore, but I'm unaware of any case in which we've adopted Skidmore. Are you aware of any case in which we've applied the Skidmore analysis?
No, but my point is that the Secretary of State is a very important elected office, and when the Secretary of State takes administrative action, there should be some level of deference that the court should weigh, but that deference given informal memoranda and documents should be only based on the persuasiveness of the Secretary of State's reasoning. So Skidmore is introduced so the court can give some deference to administrative history and look at those documents, but only to the extent they're persuasive. And here, when there's an absence of analysis, then it's not persuasive at all, and there should be no deference, and we just apply the statute.
Justice Paul Anderson.
Yeah, Counsel, your focus on photo ID is piqued question. In your brief, you essentially invite us to look at core purpose and cite voter fraud. Now, is the potential fraud that this amendment is aimed at with photo ID, is that impersonation?
I believe that there are many purposes to photo identification, but that's one of them, sure.
I mean, what else? I mean, what does photo ID do but to prevent impersonation?
Well, the driver's license, as the court may know, it includes an address, which you're voting in the right place to be a confirmation. It confirm your citizen status, non-citizens. Non-citizenship is reflected on the driver's
So
license.
now you're saying is that the amendment is to be construed as the photo ID has to include address and other things too? I mean, I read the amendment just said photo ID, valid government-issued photo ID. I'm getting even more confused now as to what this amendment means.
Well, it means that photo identification is required, which is exactly the title proposed by the legislature, which clearly...
And that's a picture of me with my name on it.
Which clearly would have been appropriate, and if Secretary of State had adopted that, we wouldn't be here.
See, I want you to answer this question for me as best you can, is that I see this photo ID aimed at impersonation, fraud if you impersonate somebody else. Do you have any empirical data of fraud in the state of Minnesota by impersonation?
Outside the record? Yeah, there's actually a funny story about that. The ACU...
No, I mean, no, you've cited the Minnesota Majority paper, which basically deals with felons, doesn't deal with impersonation. I mean...
The answer is yes, and if you want me to elaborate...
Well, yeah, go ahead.
Okay, yeah, there has been a conviction of the ACU posted that if anyone could be found that impersonated another voter, we'd pay them a certain amount of money, and the Minnesota Majority found an instance where that occurred. So
is that the incident in the Secretary of State's office? If you want to go there, I'm willing to go there, sir, but that's not a photo ID case.
Well, but you said impersonation. There's been impersonation.
Yeah, but that's not a photo ID case. I mean, I'll go there with you but if that's your sole example...
Right. It goes to the merits of the law.
Okay. Thank you, sir. You've answered my question.
Well, and
Mr. Cardall, can I just ask you about something that's actually at issue in this case? And I'm wondering if you could, on rebuttal, and you can have Mr. Lawrence do it or you can do it yourself, but I'm wondering about where in your petition you assert that the title written by the Secretary of State violates 204D.15 because it's an inappropriate title. Where, I know that's in your brief, but where is it in your petition?
All right. Thank you.
Justice Page, did you have a follow-up? No? Okay. Thank you, Mr. Cardall. Mr. Gilbert.
Chief Justice Gilday and members of the Supreme Court, my name is Alan Gilbert. I'm with the Minnesota Attorney General's Office, and with me today is Kristen Anderson and Michael Everson, who are Assistant Attorney Generals within the office. I would like to start with the first question that opposing counsel addressed, and that is who provides the title. And what I'd like to do, and it's rather basic, and it's set forth in our brief, I'd just like to talk about what the history is of providing the title for a constitutional amendment. And again, I know you're aware of this, but I think it's important that we all know what the background is and we all recognize it, because it has consequences for all the questions that I think you're asking. Since 1919, we all know that Minnesota statutes have required the Secretary of State to provide the title on the general election ballot for a proposed constitutional amendment. And what that means is that various legislatures since 1919 and various governors since 1919 have all agreed that that is the public policy of the state.
Mr. Gilbert, could
Yes.
the legislature delegate to the executive branch the authority to draft a ballot question proposing a constitutional amendment to the people?
Yes. They could. They haven't. But they have delegated to the Secretary of State the ability to do the title.
We've said that the legislature can't delegate the authority to pass a whole law or an entire law. And I'm wondering how you square that precedent with the position you just took here, which is that the legislature could ask the executive branch to draft the ballot question.
The ballot question, but of course not the proposed constitutional amendment. And that's what Article 9 says, is that the legislature can propose amendments to the Constitution. The Article 9 doesn't specifically reference the question. Breza, for example, recognizes, I believe, that there is no delegation of that function from the legislature in terms of the question. There is a delegation from the legislature with the approval of the governor as to the title. So that is clear law since 1919.
Is it your view then that the governor could veto the ballot question as passed by the legislature?
To the extent the legislature would like to delegate that to an executive branch official, then it would have to be done through ordinary legislation.
So you agree then with the opinion of the Attorney General from some decades ago that the governor, to the extent he or she tries to veto a ballot question, that veto does not operate?
I do, yes. Unless
But
there
so
is
then I'm
actual-
confused because, see, it seems to me that if the executive can't operate in the area, i.e. the executive's veto is of no effect, then how can, as a matter of separation of powers principles, how can the legislature delegate that same authority then to the executive? Do you understand what I'm asking?
I do, but in delegating it, they have to create a statute. And you create a statute
But
by
isn't it-
following the lawmaking process.
I apologize for
Yeah, no,
interrupting.
I'm sorry.
But doesn't that really just read out Article 3 of the Constitution, which says when the power is given to one branch, the other branch can't go there?
No, I don't think it does. There's authority that the legislature has to delegate legislative functions. They cannot delegate pure legislative authority. And that's what we're talking about here. Is the question a delegation of pure legislative authority? We know that they cannot delegate the function of deciding whether what the proposed constitutional amendment should be. They can't do that. The question you've raised is whether it's conceivable that under Article 9 or Article 4 that the legislature could, with the approval of the governor, delegate the question function, which has been done in other states.
But isn't the question and the title, what the people are going to vote on, isn't that all bound up in the legislature's Article 9 authority?
No, it's not, because Breza, your decision in Breza makes that very clear. The decision in Stearns makes that very clear. What's discretion as to how the amendment is going to be presented. What they have done with respect to the title, for example, is they said, you know what, we think we should delegate that function to the Secretary of State. And to do that, we're going to pass a statute. And that happened in 1919. And those statutes have been recodified, and there was another one in 1981, Governor Ritchie signed it. So that's what we have here. For some reason, the legislature and the prior governors have decided that is good public policy for this state.
Well, of course, that wouldn't really be relevant to the question of whether it's constitutional or not. I mean, somebody could, well, I beg to differ with you. I think our precedent is pretty clear that if there's an ambiguity or something, I mean, is it your position that Article 9 is ambiguous in some way?
Well, no, it's not. As to the proposed amendments to the Constitution, it's not ambiguous at all. What we're just talking about now is to what extent can the legislature delegate those functions.
Well, Counsel, I want to get to this ambiguity question. I'm looking at the second line of Article 9, and I'm going back to 6th grade and diagramming sentences again. But it says, proposed amendment shall be submitted to, shall be submitted and voted upon at the next general election. I don't find much ambiguous about that.
I don't either, Your Honor.
I mean, does that mean that the text goes to the people?
Your Honor, frankly, when I read it, that's the way I...
To be honest, and we have cases that, you know, it's kind of tangentially out there, and we make a decision, and then we don't realize the consequence. I want you to tell me, from the state's point of view, what is the best reading of the second sentence of Article 9?
Your Honor, I appreciate what you're saying, and literally, I certainly understand what you're saying. It's just the historical background is such that it's been very clear, at least from my perspective, that the legislature clearly has the sole authority to propose amendments to the Constitution.
That's the first sentence.
Without a doubt.
That's the first sentence. I agree with that.
Now, what we're talking about now is,
Counsel,
okay. Yes.
I think that's I'd like to drill down a little bit. I think this is a very close question. What does the word propose in Article 9 mean? And to me, that is really kind of the crux of the case. And I see you as interpreting that narrowly, and I see the other side as interpreting the phrase broadly. And I'm looking at Breeza, where we really adopted what we said in Stearns as far as the deference that we give to the legislature. I guess what I'm interested in is, in light of what we said in Stearns, why wouldn't we interpret it broadly to include the authority to write the title to the ballot question? You know, we determined that the power to propose a constitutional amendment includes the authority to write the ballot question language. Doesn't it logically follow that it would also include the authority to write the title? That's really, I'm interested in how you would reason
Your Honor,
through that.
And I understand your question. There is a distinction that has been made by the legislature for 90 years, a distinction that's made by the governors for 90 years, as it relates to the title, for example. They have delegated that function to the Secretary of State. The only way...
Can I just stop you there? Because I think we still get back to what the propose means, because if we interpret it to mean that the legislature has the exclusive constitutional power, then it's a non-delegable duty. And so that's why I keep coming back to propose.
And that's right.
You know, I agree with you. If it's not exclusive, then it is delegable. But I keep coming back to propose in our case law.
Your Honor, it just can't be exclusive. It has been delegated for 90 years. The consequence of now concluding that it's exclusive is that 90 years worth of constitutional amendments are now in jeopardy.
Are you talking about the fact that in Breza, we've essentially said we have a role? I mean, that's essentially what Breza is all about. We, as a judiciary, we have a role in reviewing constitutional amendments, and how could it be exclusive if we've already said we have a role?
Now, in terms of exclusive, that could mean one thing as opposed to the judiciary having review. So we're throwing around different terms. But in terms of pure legislative power, the consequence of now reconsidering 90 years of history, legislatively and case law, would be that 90 years of constitutional amendments are now in jeopardy. And if you look at some of your past precedent in terms of the standard as to when a constitutional amendment can be invalidated, it's when any constitutional standard is not followed, no matter how technical it might be, even if the electorate votes in favor of the amendment. And I would submit to you that would be an absurd proposition, and it's particularly absurd in this case because a number, fact, most of the petitioners are comprised of legislators who have issued an oath. They've sworn to uphold the Constitution and Minnesota statutes.
Counsel, what deference? Let's assume that we get by the constitutional issue here, and I want to pursue Mr. Cardall's argument here. What deference, if any, is the Secretary of State's decision entitled to? And when you answer that question, I have a quick follow-up.
Okay. Yes, Your Honor. And the case law is replete with references to the fact that there's a presumption of correctness when a state public official acts. So you have that initial presumption. And in addition to that, I would submit to you that this is analogous to the question issue. That, again, is something that the legislature has come up with in this particular situation. But if it's particularly misleading, then I think that would be the standard with the presumption of correctness that applies to any public official's act.
Now, here's my problem with that. You've talked a little bit about the problems that exist going backwards, and I have a problem here going forward. And it seems to me that the invitation that you are issuing to us is an invitation to a party which involves constant conflict between the legislature and the Secretary of State over the amendments, titles to constitutional amendments. In other words, what your proposal, where that puts us, it seems to me, is in most election years, in most general election years, we're going to have a separation of powers argument every summer. Because if we go down this road, it seems to me that's where that leads.
Not if you decide it, in this case, in one particular way. But go ahead.
But that's my point about the standard of review. I don't think anybody here argues that the Secretary of State's decision is entitled to the high constitutional deference standard, that we have applied in some of our cases dealing with language. So then, if we go to a lesser standard, that means there's going to be these kinds of disputes on a constant basis. And it seems to me that that's not what the founders had in mind with Article 9. Now, I'll agree that they didn't actually say that titles were in fact part of the constitutional responsibility here. But nonetheless, it seems to me that that's a possible, indeed, I would say likely, consequence of the position taken by the state here. Am I right or wrong?
Your Honor, I disagree with that. First of all, I think appropriate in this context, with the presumption that I just referred to, means, is it accurate? We're talking about a title that by statute.
I think Mr. Cardall's argument, I mean, I'm not crediting it in the sense that I agree with it, but on its face, his argument that statutory language that makes reference to photo identification that is referred to by that way in correspondence by the parties, and yet the Secretary of State chooses not to use that phrase. If you're using something less than that highest constitutional deference standard, it seems to me there's a problem there. Now, maybe you're right. Maybe it doesn't meet the standard, and we're okay. But it strikes me that this is the kind of argument we're going to have every 4 years or 2 years, I guess.
Perhaps, Your Honor. I would hope not. I think that again, the standard should be: is this accurate? And Your Honor, I would, on the merits of what you're describing here, I'm looking at the two alternative titles. One is photo identification required for voting, and that's it. The amendment includes a heck of a lot more, as you know. The Secretary's title actually accurately reflects the entirety, the full breadth of the constitutional amendment. That's what the voters are entitled to know about.
Counsel, can I ask you about the Secretary of State's letter to me dated June 14th?
Yes.
I assume you're familiar with that letter.
I am.
Is there any relevance in this case to the Secretary of State's assertion in that letter that his authority in this area is purely, quote, ministerial, end quote?
I don't think so, Your Honor. I think he was referring to his general functions in terms of preparing the ballot and in terms of him abiding by whatever you decide with respect to the misleading question.
But if in fact his authority is purely, as he said in his letter, ministerial, then if the legislature chooses the title, wouldn't it be the Secretary of State's obligation to take that title and put it on the ballot? Because if something is purely ministerial under our precedent, that means the official at issue doesn't exercise discretion. There's no thought. I mean, it's just, all right, it's a rote kind of a deal. It's automatic.
Your Honor, I'm not sure that's true with the case law. I mean, ministerial, it means something that doesn't require a lot of discretion, but in any public official act, there is some discretion. I think the cases recognize that as well.
But in any event, your argument is that that letter is only about ballot
That's my understanding.
questions,
yes.
or?
Well, it's only about preparing the ballot and, in particular, abiding by whatever the court decides in that particular petition.
Counsel, can I loop back to Justice Barry Anderson's question?
Yes.
And I'm going to quite frankly submit I think you missed the bigger picture.
Okay.
Democracy is messy.
Be the first time.
Democracy is messy, and is that I think our founders said is that they're going to give a limited grant of power, and they don't trust any of us, so they divided it. I would submit that a constitutional amendment is so important that actually in 1919 or whatever, the legislature recognized the importance of it and recognized the role of separation in powers and said, we will delegate the title, just so we make sure there's some input. The governor doesn't get the right to veto. Now, this is messy, and Justice Anderson, Barry Anderson may be right. We may be setting it up. But, I mean, don't they have the right to put in that check and balance? And if they repeal that, they could do it, but aren't we left with what they did and say, we want this protection in place, messy as it may be?
Your Honor, I cannot agree more with you, and that's the public policy that I'm referring to and that we refer to in our brief. And that's our lawmaking process, where the legislature and the governor decide what should be our public policy on that issue. And what they decided, for whatever reason, is precisely what you said, that there needs to be some sort of check, and that the legislature will propose the constitutional amendments. That's pure legislative authority. They will propose the question, because there's no statute that allows anybody else to do that. But as to the title, they knowingly and specifically provided that the Secretary of State will provide the title. And if you look at the Bergman case, which is the Missouri Court of Appeals case, which is right on this, and it's all right on all fours, that's what they say. It's a matter of separation of powers, and that was what was recognized by the Missouri legislature when they adopted the statutes that are similar to ours.
Counsel, let me ask you about the word appropriate. You had mentioned in response to the Chief Justice's, I think, question, or maybe it was Justice Barry Anderson's question, that you think appropriate is accurate.
Yes,
that is actually not the definition of appropriate, and I looked in 2 or 3 different dictionaries. Appropriate is suitable or compatible. It's not accurate. And so my question for you is, why is it appropriate? I mean, I actually think that that opposing counsel has a good argument that the Secretary of State does not put an appropriate title on the ballot when it ignores the title that was put on by the legislature. Because the legislature, in other words, even if you use the constitutional avoidance canon, right, we have an ambiguous statute, what does appropriate mean? You still get to the point where you say, you know, maybe it's not appropriate because the legislature perhaps has exclusive authority in this area.
Your Honor, I understand there's a couple of questions there, but let me just get to the issue of appropriate. And you're right, it means suitable. But under the circumstances, what I'd like to do is analogize this to the title on a legislative bill. And you guys have these cases all the time. I'm sorry. You justices have these cases all the time that deal with log rolling and things of that kind. It's really a significant public policy when it comes to that. And I'm looking at the Wass versus Anderson case from 1977 of this court, when they said when it comes to the title on a legislative bill, this is the function of the title. And this is on a legislative bill, and I would submit to you it's even more important when you talk about a constitutional amendment. And the function of the title requirement as to a legislative bill, according to the Wass case, is to provide notice of the interests likely to be affected by the law and to prevent fraud and surprise upon the people. I would submit to you that same principle should apply to a constitutional amendment title. And in that sense, Justice Strauss, I think accuracy is imperative. And that's my point. As long as it's accurate, the voters have a chance of understanding it. And the voters need to be as informed as possible, especially when you talk about the voting amendment.
So you would agree then that the title does have an impact on the voters?
I think it's a package, Your Honor.
Well, if it has an impact on the voters, then I can't understand why it's not part of the legislature's exclusive authority under Article 9 to propose amendments to the people. In other words, I think this is a deal between the legislative branch and the people of Minnesota, and that's it.
But that's not the history for 90 years, and that places in jeopardy 90 years of constitutional amendments if that's true.
But haven't we said, in effect, the fact that somebody has been behaving unconstitutionally for years, I mean, let's look in the area of gender discrimination, for example. That doesn't make it right.
But Your Honor, with all due respect, it doesn't really make any sense. For 90 years, the Secretary of State has had this pure legislative authority, which, by the way, these folks refer to as ministerial authority. Go ahead.
No.
I'm sorry.
I apologize for interrupting.
No. I mean, with all due respect, I mean, that's the history of this state. But getting back to Justice Anderson's point, and I think it relates to what you're saying as well, it's the public policy that's been created by prior legislatures and prior governors.
Counselor,
they wanted some sort of balance.
Do you agree that the legislature has the power to repeal the statute and eliminate the Secretary of State's role in determining or formulating the title?
With the approval of the governor, or yes. Going through the proper lawmaking process, which is precisely what happened in Missouri after the Missouri decision was
So
decided.
you think that delegation is pursuant to the Article 4 lawmaking and not delegation under Article 9?
Your Honor, we cite to cases, I think it could be either conceivably. We cite to cases that say when the Constitution is not otherwise clear, that the legislature has the authority to try to delegate to implement the statute, the constitutional provision, I should say. And we cite to examples in terms of eminent domain and other things as well. So the case law of this court is very clear that the legislature can prescribe by law the implementation of various constitutional provisions. So I think they can do that under Article 9, or they could do it under Article 4.
Counsel, as we discuss this, I'm reminded of a book written by my advisor and mentor at Macalester College, G.T. Mito, Approximate Solutions to Unsolvable Problems. Mm-hmm. These are emotionally charged, politically motivated amendments. And I see it almost unsolvable problem because one side is going to say it described this way, one side is described the other. And I see problems with both descriptions. And I'm wanting to say is, do we have the power to say a pox in both houses? All you say to the people is, shall the Constitution be amended to read, boom, yes or no, and put the full text there? Is that an alternative before us?
Yes, I think it is, Your Honor. And, you know, one thing I did listen to...
In that regard, you do agree that the legislature has validly passed a proposed amendment. All we're talking about is the how of how it goes to the people.
Yes. In terms, you're going to the idea of remedy here, whether it be the broader issues that you've dealt with in the other petition or the title issue here. Keep in mind, and I know you're aware of this, but this is an original jurisdiction case. You only have original jurisdiction over remedial matters. And the statute under which you have original jurisdiction specifically says you can correct the ballot and take other appropriate relief if there are errors or omissions or whatever you might find. So, by definition, you have remedies. By your authority, you have remedies. Otherwise, you couldn't have original jurisdiction of this matter. And I think, frankly, and the Attorney General thinks, and I believe the Secretary of State would agree, that that is one alternative. Put the whole proposed constitutional amendment on the ballot. You have other alternatives, though.
No, in
Well,
that regard,
it's interesting that the Secretary of State's making that argument in this case and not the case where...
Your Honor, I will retract that. You're absolutely right. He is not taking position in the other. But in terms of the Attorney General, who's a party here, the Attorney General would very much support that as a proper remedy.
Now, the marriage amendment text is going to be on the ballot, right? The full text.
Not that I'm aware of.
I thought it was.
Okay.
Well, maybe I'm wrong.
Wait, it's so short.
Okay.
It's so short, it's possible.
I'll check.
Yeah.
Any other questions from the court? Mr. Gilbert, we've taken a lot of your time. Do you want a few minutes to sum up, or are you good?
Your Honor, again, I'll just say that I think we have to keep in mind there's been a public policy decision for 90 years made. And for that decision to be changed, it has to be done through the lawmaking process. That's another constitutional provision that has to be followed. In terms of the appropriateness of the titles, we've briefed that rather thoroughly. We think that they're very, very clearly accurate titles under the circumstances. They help to inform the voter. That's the purpose of the title, as I've indicated in analogizing it to the purpose of a title for a bill.
I want to clarify that argument and go back to something the Chief talked about earlier. She said, if it was a mistake, do we perpetuate that mistake? Or like in gender discrimination, racial discrimination, if we conclude it's wrong, do we get to change it?
Your Honor, I don't think it's a mistake, and I think the fact that it endured and still endures for over 90 years establishes it's not a mistake. I think just by historical reference, it's clear that this is not pure legislative power.
Thank you, Mr.
Thank
Gilbert.
you very much.
Mr. Lawrence, you have 5 minutes for rebuttal.
Your Honor, in response to your question about the did we say in our petition this is not an appropriate title under 204D.15, that language doesn't exist in the petition. The closest we come to is paragraph 35, where we say that it was an error for the Secretary to substitute the title for the one that the legislature did.
So then what is actually before us, I guess, is the question, assuming that we do have case law that suggests that you have to put all of your arguments in the petition and then repeat them in the brief. And so you argue essentially in the brief about appropriateness. I mean, more or less. I mean, I sort of summarize the appropriateness point. But what is actually before us? You don't actually make the claim, I think, in your brief directly or explicitly that this delegation of authority is unconstitutional. And so I'm kind of left to wonder what we're actually deciding today.
That this is an error, an omission under the errors and omission statute, in that the Secretary of State did not recognize a validly enacted law that states this is the legislature saying to the Secretary of State, this is the title you put on the ballot. And the Secretary of State said, I don't have to because of 204D.15. So I think that the question before the court is, who has final authority, the Secretary operating under this statute or the legislature when it adds this, has this provision as part of the constitutional package that's put forward? And we would argue that the legislature can delegate it through the statute, but it also can act directly and say this fulfills the statutory requirement.
Which gets us back to the appropriateness, which the Chief asked you whether it was in the petition. So my question really is, you know, aside from the petition, do you want us to address, I mean, do you want us to address both the statutory argument and the constitutional argument you're making, or one or the other?
I think if you address the constitutional argument, you don't have to address the statutory one, is the way that I would put this. And I think that this is, even though we're saying that this is an exclusive authority of the legislature, I don't think that this means that the legislature has to set up its own ballot system. I think that it can use the Secretary of State to direct how this is presented to the voters. That's not the kind of non-delegable power that this court had in mind when it speaks about that it's directing the details of this here, and I think that the only way the statute is unconstitutional argument is with the state's argument that the only way the statute can be changed is by the regular ordinary process under Article 4. And if that doesn't happen, the legislature's hand has tied its own hands.
Well, let me ask you this. I actually saw that there's another state. I mean, I read that there's another state dealing with a related question, which is the legislature is asserting in that state under its exclusive authority that it has the power to prescribe fonts on the ballot for a constitutional amendment. There's a huge battle in another state about this. Would you say fonts? The size of the font?
Oh, fonts. Okay,
yeah,
yes.
And the type of the font. Apparently, there's research that suggests that has a huge impact on whether people accept a constitutional amendment or not. My question for you is, what makes the title different from fonts. I would think, maybe you are making this argument, but I would think you would not be suggesting to us that the legislature has the exclusive authority to prescribe fonts on the pink ballot that is given to the voters.
I hope this court and I never have to argue a case about fonts. I think that the ballot title is significant, and that we see that just generally throughout the history of the Minnesota legislature, they dictate what appears on the ballot. That seems to be, if we're talking about this 90-year history of the statute, there's even an older history, and that's the practice of the legislature is to dictate what goes into appears on the ballot, and that the Secretary of State has just basically agreed to and gone along with that over the years.
Counsel, speaking, you know, we've had a lot of talk about the 90-year history of the statute, and I guess it gets me back to the sort of the fundamental question here, is that Article 9, Section 1 talks about proposed amendments, and obviously in Stern and Duluth and Breeza we've said proposed amendments includes the form and manner, but it strikes me that that's something that we might be called on to revisit here. Do you see that as, given the history, is that something that we can revisit?
I mean, I guess this court could. I mean, you're the highest court in the state here. I think that I think this might be more helpful. It's to view this as this Article 9 says there's proposing and then there's voting. There's a two-part process. The legislature oversees the first part, and the voters oversee the second part. And I don't think that it is so exclusive to the point where there's a constitutional requirement that the legislature, for example, has to set up its own independent ballot system that it only runs when there's a vote on constitutional amendments. I think that it can delegate the ministerial function to the Secretary of State and direct what aspects it views as the larger picture aspects. I don't think we have any big picture questions here on whether exactly what's the best wording or something like that. It's only who is the final authority, and I think it's clearly the legislature.
Well, but this does raise the question, it seems to me, as to whether in fact the ballot question, the ballot title, constitute a proposed amendment. I mean, people aren't, when all is said and done, in both cases, what the people will be voting on and what will end up in the Constitution, if in fact they are passed, is not the ballot question and not the title. And so fundamentally, does Article 9, Section 1 require that the proposed language of the amendment that will ultimately end up in the Constitution, if passed, is that what should be in front of the voter?
Well, if this court were to re-examine whether, the proposing amendment, the first sentence of Article 9, is really much more narrower than if this is a relevant question. I think that would be it would be wrong to backtrack and to shrink down what this court has said in the past, because you would then have to say something like there's this the legislature proposes, the voters vote, and then there's this kind of middle ground area that's dealt with by somebody else, that the plenary authority is with the Secretary of State or some other entity. And I think it makes more sense that to me would just be entering kind of a black hole of constitutional interpretation, and it would be better to just say the legislature proposes, the voters vote on the proposal.
Well, it strikes me that once the legislature proposes the amendment, the rest of it is like the font. You decide somebody decides what size it goes in, but legislative language goes into the, is the question.
Well, I think that it would be, the best answer would be to say the legislature either says this is the answer or defers.
Should the Minnesota Constitution be amended to read as follows? How complicated can that be?
That would be a possible
It'd be a lot less
interpretation.
complicated than what we've been through the last couple of weeks.
We would not urge that. We would urge just that when the legislature speaks to these matters, the deference goes to them, and the Secretary of State can't weigh in based on a statute.
Counsel, I want to follow up on that. Should we conclude that it's so unsolvable, both sides have messed up, do we have the power and authority to say the question could be as simple as this: shall Article 7, Section 1 of the Minnesota Constitution be amended to add two subdivisions would read as follows? The full text, yes or no? The state says we have that because this is a remedial matter, and if both sides get the question or the title wrong, we can provide a remedy.
Well, I think that if you were to do that, what you'd have to do is first say, well, some of these older decisions that say the form and manner, we're really wrong, and that really the legislature can only just propose the text, and that the second sentence means that the only thing that can go onto the ballot is the actual text of the amendment or something like that. And I think that would be injecting a level of judicial oversight to the process that is not warranted by the text. And
but see, some of the alternatives are worse. I mean, in the first case, they said take the whole proposed amendment off the ballot. That would be very activist on our part. But if the question and the title are not correct and we come to that conclusion, do we get to draft the title then? What do we do?
No, I do not think so. And I think that you have a different situation than like in the League of Women Voters case. That what you have here is two competing entities, governmental entities, saying this is what the ballot title is going to be. And this court, I think, it's a just much narrower, easier question, is the fact that the Secretary of State is basing acting on the statute, or the legislature weighing in as part of its authority to propose the Constitution. Who is the final say? And to me, that's a much different question. That is this appropriate? Is this deceptive? I don't think any of those kind of subjective questions.
So I'm asking you now. You're telling us to decide. I take the Secretary of State's articulation on one side, the legislatures on the other. I find them both deficient, but I have to take the better of the two and then say, that's it?
No, I don't think you have to do it that way. You have to say, who is the higher authority to speak? It's not you're saying, this is the way I would urge you to say it, is to say the legislature delegates in a residual sense its authority to write ballot titles as part of its Article 9 authority through the statute 204D.15. But it is free to pull it back on specific amendments, which it did with the Legacy Amendment, marriage, and voter ID. And that's what it did here. Then you give effect to all the legislation or all the lawmaking that's gone on. The provisions that were passed by the legislature, and there's no invalidating of 204D.15. So to me, it just seems to be a much narrower question, and that you don't have to get into these larger constitutional questions like that.
Counsel, your time has expired, but Justice Strauss has a question.
Is there a particular language in Article 9 that leads you to this proposition, or is your argument, it's the essence of your argument, is that the legislature has some sort of inherent authority to pass a title, even in light of the statutory provision? In other words, is it a textual argument you're making, or is it more of an inherent authority?
Yes, on the word propose. That propose is broader than just writing the four corners of the text, and that then I would also say textually that Article 9 just basically has two players, the legislature and the voters. And I think delegating to the Secretary of State how to prepare the ballot is not delegating exclusive authority in the way that this court has said is improper under the Constitution. Thank you.
Thank you, Mr. Lawrence. Mr. Cardall, did you have a response to my question? Yes. If I could just have you go to, at the risk of opening up.
I promise, no questions.
The question was with respect to where in the petition.
Yes.
Yes. And this is my claim
Yes.
that we're talking about. And so at paragraph 19 and 20, it referred to the Secretary placing the appropriate title on each proposed amendment. And then page 12 in paragraph 34 says basically says that actions of the Secretary and Attorney General are unlawful and exceed their constitutional authority. That's under the cause of action. And then it refers to, the errors being made. And the prayer for relief, petitioner requests this court for an entry of judgment in their favor and against Secretary of State, Mark Ritchie, and it goes on, finding that they had erred in substituting approving the proposed ballot title. The issue comes up, if I just may add one thing.
Yes.
The issue comes up in 1983 litigation as well, in that there's a general statute here, 204B.44, creating a process to bring the claims to this court. But of course, it doesn't create substantive rights like 42 U.S.C. 1983 and 204B.44 don't create substantive rights. It creates a process. You still have to point to a substantive piece of law. So we might have a First Amendment case. Someone else might refer to it as a 1983 case. Here we have an inappropriate title case, but someone might refer to it as a 204B.44 case. So when we refer to the error under 204B.44 as being the inappropriate title, we're saying one and the same thing, just like when we say in a First Amendment case it's a civil rights violation, we're also saying it's a First Amendment violation. Thank you, Your Honor.
Thank you, counsel. Thanks to all counsel for your help in these cases. These matters are submitted, and we are in recess.